Good morning. The Judiciary Committee will come to order, and without objection, the Chair is authorized to declare a recess of the committee at any time. Pursuant to notice, I now call up H.R. 5046 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 5046, to amend the Omnibus Crime Control and Safe Streets Act of 1968 to authorize the Attorney General to make grants to assist state and local governments in addressing the national epidemic of opioid use and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point, and I'll begin by recognizing myself for an opening statement. Today we continue with the committee's efforts to combat the opioid epidemic. H.R. 5046, the Comprehensive Opioid Abuse Reduction Act, was authored by our colleague, Crime Subcommittee Chairman Jim Sensenbrenner, to provide resources to states, localities, Indian tribes, and others to help fight this historic problem. I am pleased to be an original co-sponsor of this bill, along with Ranking Member John Conyers, Subcommittee Ranking Member Sheila Jackson-Lee, and Congressman Steve Shabbat, Randy Forbes, and Mike Bishop. I thank my colleagues for their partnership and support. Today, the United States is in the throes of an epidemic of prescription opioid and heroin abuse. Every member on this dais has heard a tragic story about a constituent who has become addicted to opioids, and tragically, many have lost their lives in the addiction. In fact, statistics show that approximately 46,000 Americans die from a drug overdose each year. That amounts to nearly 130 overdose deaths every day. Recent studies have shown that more than half of chronic prescription drug abusers received those pills from prescriptions written for them or for friends and family. In 2014, in my home state of Virginia, the number of drug overdose deaths surpassed the number of traffic fatalities for the first time. This is a problem that affects Americans in all regions of the country, across all socioeconomic levels, and one that has rightfully gained Congress's attention. H.R. 5046 is an important, reasonable piece of legislation that will do a great deal to combat the opioid epidemic. It creates a comprehensive opioid abuse reduction program at the Department of Justice, which will direct federal resources for drug abuse programs directly at the opioid problem. By styling this as a competitive grant program for opioids, this bill will give states and localities maximum flexibility to attack opioid abuse issues unique to their communities. States will be able to use the grant funds for a variety of important programs, including alternatives to incarceration, treatment programs for incarcerated individuals, juvenile opioid abuse, investigation and enforcement of drug trafficking and distribution laws, and significantly, training for first responders in carrying and administering opioid overdose reversal drugs like naloxone. States will also be allowed to enlist nonprofit organizations, including faith-based organizations, in the fight against opioid abuse. The bill authorizes this new program at $103 million annually over 5 years. The comprehensive grant program created by H.R. 5046 is fully offset. This means that we have successfully directed funds to address the opioid epidemic by taking advantage of existing funding streams to Department of Justice grant programs. The result is no net increase in spending authorizations and no additional burden on the American taxpayer, which is a responsible, good government approach to this epidemic. H.R. 5046 is thoughtful, responsible legislation that, once enacted, will help fulfill Congress's duty to protect the American people. I would also like to remind members that today, from 10 a.m. to 2 p.m., House Appropriations Chairman Hal Rogers and I are sponsoring a Federal Take Back Day in 2359 Rayburn, where members and congressional staff can return their unused prescription medications. We all know that prescription drugs that linger in homes are susceptible to diversion and abuse. As Congress considers legislation to tackle the opioid epidemic, I encourage my colleagues to attend this important event to show your support for the Take Back program. And I urge my colleagues to support H.R. 5046. It's now my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members of the committee, I'm pleased to join with the chairman as an original co-sponsor, along with Crime Subcommittee Ranking Member Sheila Jackson-Lee of Texas, of H.R. 5046, the Comprehensive Opioid Abuse Reduction Act. And I commend the chairman of the Crime Subcommittee, Jim Sensenbrenner of Wisconsin, for his leadership as the author of this important legislation, which is intended to combat the opioid abuse epidemic. Although the Senate has passed a version of the Comprehensive Abuse and Recovery Act that many believe is a commendable bill, H.R. 5046 is a good faith effort to accomplish the same goals as that other bill. We are in the midst, as we know, of a major public health crisis caused by drug abuse. According to the Centers for Disease Control and Prevention, 78 Americans die from an opioid overdose every single day. In my state of Michigan, there were 1,745 drug overdose deaths in 2014. That was double the amount of people who died in automobile car crashes the same year, making drug overdoses a leading cause of death in Michigan. And more than half of those overdose deaths were attributed to opioids and heroin. I'm very familiar with the devastation heroin can cause over people and their community. Heroin took a deadly toll on Detroit in the 1970s and is now threatening to take hold of a new generation of addicts. We can and we must do more to address this crisis. Fortunately, various states have undertaken innovative measures to better respond to the rapid increases of individuals addicted to prescription opioids and heroin, and to prevent individuals from dying as a result of drug overdose. For instance, the Crime Subcommittee held a hearing last year about the growing heroin crisis, and the district attorney from Santa Fe, New Mexico, testified about the promising use of the law enforcement assisted diversion approach employed there. We have learned that there are ways to get addicts to treatment and needed services quickly that are successful at addressing their addiction and preventing recidivism. And we know that treatment alternatives to our incarceration work. I support this bill, H.R. 5046, because it will help provide critical grants that states can use to fund these innovative programs that will help prevent and treat opioid addiction. In addition, this bill is an important complement to other legislation working its way through this and other committees. And so I thank the chairman for bringing this up, and I, of course, urge all my colleagues on the committee to support this bill. Thank you, and I yield back.
Thank you, Mr. Conyers, and I'd now like to recognize the chairman of the Subcommittee on Crime, Terrorism, Homeland Security, and Investigations, Mr. Sensenbrenner of Wisconsin, also the chief author of this legislation, for his opening statement.
Good morning. I would like to thank Chairman Goodlatte for holding this morning's markup of the Comprehensive Opioid Abuse Reduction Act of 2016. The House Judiciary Committee, along with the House Energy and Commerce Committee, are marking up more than a dozen bills this week to address the growing problem of opioids in America. I am optimistic that we can pass meaningful legislation and send it to the President for his signature this Congress. The misuse of and addiction to opioids such as heroin, morphine, and other prescription pain medications has had a devastating hold on this country. It affects every state and every district, and the moral, emotional, physical, and financial toll has been tremendous. Between 435,000 and 1.5 million people in the United States currently use heroin, and an alarming number of them are younger than 25 years old. Even more alarming, between 2002 and 2013, national heroin deaths nearly quadrupled, reaching more than 8,000 annually by 2013. Beyond health care costs, other significant economic burdens are associated with opioid abuse. These include costs related to criminal justice and lost workplace productivity. In total, opioid abuse imposes an estimated $55 billion in societal costs annually. My home state of Wisconsin has experienced a 350% increase in heroin samples submitted to the Wisconsin State Crime Laboratory by law enforcement. The number of heroin-related deaths jumped by nearly 50%, and statewide data shows 1/4 of Wisconsinites who abused the drug began using when they were younger than 25 years old. All over the country, people are calling on Congress to find solutions. In town hall meetings, on the campaign trail, and through social media, lawmakers are hearing heartbreaking stories from families and friends of addicted individuals and leaders of impacted communities. The most effective way to approach addiction is to pursue a comprehensive response, which must include a strict focus on prevention, law enforcement strategies to stop drug dealers and traffickers, the plan to address overdosing, and expansion of evidence-based treatment options for those struggling with addiction. The Comprehensive Opioid Abuse Reduction Act is an important piece of the puzzle. My legislation will provide states and localities with additional resources to tackle this crisis. The legislation authorizes the Attorney General to make grants available for a number of services related to opioid abuse. The grant program contains 8 allowable uses for the grant funds, which are broadly construed to give states flexibility in responding to the opioid epidemic within their borders. These include alternatives to incarceration programs, collaboration between criminal justice agencies and substance abuse systems, training for the first responders in carrying and administering opioid overdose reversal drugs, including naloxone, and prescription drug monitoring programs. The legislation also contains strong accountability provisions to ensure that the funding is spent wisely. This issue touches the life of every American. It is imperative that we pursue aggressive measures to stint its dangerous progression for a stronger, more prosperous America. The Comprehensive Opioid Abuse Reduction Act is common sense, bipartisan, and addresses the issue head-on and will make a positive impact in our fight against addiction. I urge my colleagues to support this measure and yield back the balance of my time.
Thank you, Mr. Sensenbrenner. And now I'd like to recognize the ranking member of the Subcommittee on Crime, Terrorism, Homeland Security, and Investigations, the gentlewoman from Texas, Ms. Jackson Lee, for her opening statement.
Good morning. I thank the chairman, the ranking member, and I thank the chairman of the subcommittee for his leadership on this issue. I'm very happy to be part of the original co-sponsors on, I think, a very important statement that we're making and action that generates results. Might I remind people that even though the investigation is not complete, 8 people were killed in Ohio around some suspicions of drug activity. Although opioid is not alleged to be one of the drugs, we know it was around drug activity. That means people are using, people are buying, and people are being addicted. And that is the epidemic, of course, of opioid that is across this country. I support and am an original co-sponsor of the Comprehensive Opioid Abuse Reduction Act of 2016. I commend the chairman of the Subcommittee on Crime, Mr. Sensenbrenner, for his work on this bill, and I also commend Chairman Goodlatte, Ranking Member Conyers, for their work in finding common ground on this bill. I also note that I was a co-sponsor of the predecessor bill, the Comprehensive Addiction and Recovery Act. And in our effort to reform the criminal justice system, clearly, among the many issues, including mandatory minimums that sent individuals to prison for 25 years and above, just simply by being a user, this legislation hits the right tone. It is to address the addiction through the Department of Justice through a grant program that is administered by the Department of Justice. I would have been happy to see that bill adopted by this committee, but I'm glad that we worked together and look forward to continuing to work with my colleagues to address issues related to drug abuse, whether they be opioids or other drugs. We must take action because today a leading killer of Americans is drug overdose. Between 2000 and 2014, almost 500,000 people died from drug overdoses. In 2014 alone, more than 47,000 people died of drug overdoses. The largest percentage of overdose deaths in 2014 was attributed to opioids like prescription painkillers, methadone, morphine, and heroin. Specifically, 28,647 people overdosed and died because of an opioid in 2014. We are experiencing a crisis, and I am concerned about the perilous connection between prescription painkillers and heroin. Approximately 3 out of 4 new heroin users report that their use began with their abuse of prescription painkillers. Prescription painkiller abuse is the strongest risk factor for future heroin use. Heroin tempts those addicted to prescription painkillers because it is cheaper and easier to obtain. Due to its potency, heroin use tends to lead to addiction. Heroin addiction is often deadly, leading to overdose and other chronic diseases. The rate at which the occurrence of overdose deaths attributed to heroin has increased is frightening. And if you talk to members of Congress all over this House and Senate, you will hear horror stories from their respective congressional districts and their states. In the 4 years between 2010 and 2014, heroin overdoses tripled. More than 10,500 people died from heroin overdoses in 2014. In 2013, more than 8,200 people died from heroin. In that same year, 11 million people admitted to improper use of prescription painkillers. Not only were 11 million people at risk of overdosing due to their abuse of prescription painkillers, 11 million people were also at risk of becoming addicting to heroin, which is attendant risks and dangers. It impacts people of all ages, from senior citizens to working families to young people to children. Because of this current crisis, we must take action, and the bill before us today will do so. And the important element of this bill deals with treatment and prevention and education, training, integration of services, and other resources. We must put our best efforts forward to prevent individuals from moving from painkillers to heroin. And yes, we cannot fill up our jails, our prisons, with individuals who are sick, who are addicted. Life-saving overdose reversal drugs like naloxone are most valuable in the hands of trained individuals who regularly come in contact with individuals. Treatment is key. This bill will increase the use and availability of these reversal drugs and other overdose reversal drugs to first responders. Addiction is a disease that affects the brain, eventually changes the behavior of addicts, and there is nothing else they want but to get that drug. This bill encourages the development of alternatives to incarceration that provide treatment as a solution to the underlying motivation for criminal behavior or conduct associated with mental disorders. It is our job to be the bully pulpit of good things, to stop this scourge of drug addiction and heroin use, among other drugs, across America. And I joined with the Opioid Caucus last week and introduced a number of bills that were going to be helpful, and I'm very glad to be part of this bill and the reintroduction of the Comprehensive Opioid Abuse Reduction Act of 2016, and I ask my colleagues to support this legislation. I yield back.
Thank you, Ms. Jackson-Lee. Without objection, all other members' opening statements will be made a part of the record. Are there any amendments to H.R. 5046? For what purpose does the gentlewoman from California seek recognition?
Mr. Chair, I'd like to strike the last word.
Gentlewoman is recognized for 5 minutes.
Thank you. Mr. Chair, let me thank the leadership of the committee and the subcommittee for bringing forward this legislation. I'm proud to be a co-sponsor of it, and I feel like the current epidemic that is going on in our country, based on what has happened previously, I think this time we're going to get it right, meaning that our focus is going to be on treatment, and this is what this legislation is calling for. It does remind me of the past, 25 years ago, when there was a epidemic around crack cocaine. We didn't know that much about addiction at the time, and pretty much our response was focused on law enforcement. And this certainly led to a massive increase in the foster youth population, because it was one of the first times when you had women using drugs equal to men. That really hadn't happened before. And so when a woman uses a drug, the family falls apart and the kids are removed into foster care. This is happening currently with the heroin addiction, and also the prescription drugs, that foster care population is increasing again. But this time I hope that we get this side of it right as well, and instead of taking the children away, that we recognize that you can actually keep the family together and provide treatment. And there's a lot of evidence-based practices around the country that have demonstrated that you can, maybe you might have to temporarily take the kids away, but you could reunite the family after the mother goes into recovery. So many years ago, when we had a strictly law enforcement approach, there was a lot of collateral damage to that, and some of it we're dealing with now when we're looking at criminal justice reform. One of the reasons we're looking at criminal justice reform is because of the way we approached an epidemic years ago. But there is still some collateral consequences of laws that were passed years ago, and I want to make mention of one of them. And that is the fact that if a young person had a drug offense, after they were incarcerated and were released, they then were not eligible for financial aid for college. So I'm talking about somebody that has already faced the justice system, but they're also subject to extrajudicial consequences of losing their college aid. So if they've already been in front of a judge and they've paid their debt to society, then we have to think about whether or not we really want to have the collateral punishment that prevents them from continuing their education. So I've introduced the Success Act to fix that broken policy. At the heart of the Success Act is forgiveness and grace. We should be helping young people who want to go to school and get their lives on track, not making it harder for them to obtain education because of a youthful indiscretion. So the point I'm trying to make is that I think this legislation is good. I'm glad we're moving forward with it. I'm glad that our focus now is on treatment. But when we passed laws years ago, we need to take a look at some of the collateral consequences of legislation that we did, especially given what we know now about addiction, brain science, treatment, recovery, et cetera. And so I'm hoping that we pass this legislation today, but as we continue in this committee to consider criminal justice reform, that we look at some of the laws we passed previously and maybe reconsider them. Thank you very much. I yield back my time.
What purpose does the gentleman from Rhode Island seek recognition?
Mr. Chairman, I would like to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman, and thank you and Ranking Member Conyers for your leadership on this critical issue. This epidemic is destroying lives and ravaging communities, and the impact of this crisis is being felt in my home state of Rhode Island, and an evidence-based prevention and treatment approach is absolutely the right answer. I applaud the work of my colleagues in crafting this legislation, but I hope that this is only the first step in a larger effort to address this national public health crisis. I appreciate that this bill represents a critical and substantive effort to help those in our communities who are suffering from opioid addiction. And I recognize that this is one piece of a package of bills moving through several House committees. However, even when viewed from this perspective, I believe that we must do more as a Congress to promote prevention and recovery. Recognizing this responsibility, our colleagues in the Senate endorsed a broader approach, passing the Comprehensive Addiction and Recovery Act, also known as CARA, by an overwhelming 94-to-1 vote, authored by my colleague from Rhode Island, Senator Whitehouse. CARA was introduced in the House by the gentleman from Wisconsin and has earned the support of 125 members of the House and includes several important programs that have been excluded from the bills that are currently under consideration. I understand that some of the exclusions may be the result of committee jurisdiction limitations of this committee, but these provisions are also not currently included in the overall package of bills being considered by the other committees as well. They include programs that would allow for the development and expansion of community-based recovery services through the Department of Health and Human Services. They include prevention initiatives to promote greater awareness of the risks associated with prescription drug abuse, and they include programs specifically designed to improve treatment for pregnant and postpartum women and to improve recovery among young adults. These provisions represent fundamental components of a comprehensive approach to stem opioid abuse in our communities, but none of these programs have been included in the package of legislation currently being considered in the House. In the more specific context of today's markup, the bill before the committee excludes the expansion of the prescription take-back program. While I recognize the merits of this bill and plan to support it, and I'm pleased that we're taking it up today, I'm concerned about the vital components of CARA that we've left behind. The public health crisis that our communities face requires a comprehensive solution. It should encourage greater coordination between healthcare professionals and law enforcement. It should incentivize states and localities to adopt an integrated approach that includes prevention and recovery rather than focusing solely on treatment and enforcement. And it should be designed to help some of those who may be most vulnerable to abuse, such as those in recovery or correctional settings. With this in mind, I hope that this committee will continue to work together to reduce opioid drug abuse and to address some of these really critical gaps. But I again want to thank you, Mr. Chairman, for your leadership and look forward to supporting the bill. And with that, I yield back.
Chair thanks the gentleman. Are there any amendments to H.R. 5046? For purposes, the gentleman from Louisiana seek recognition.
Mr. Chairman, I move to strike the last word.
The gentleman is recognized for 5 minutes.
Mr. Chairman, let me applaud you and the ranking members and the two ranking members of the subcommittees for some really good work here. And I would just encourage that we continue to look for areas that we know there's a problem and we know that the response has been inadequate. And with opioid abuse, it has been clear, and Congress on both sides of the aisle, both chambers, are moving to do something about it. But I would just continue to stress that we not let where the problem lies, whether it's suburban America or urban America, dictate the speed at which we work to solve problems. And I would just highlight the fact when we talk about crack cocaine and the response versus the response to opioid, when you compare it to those that are addicted and where the problem has recently crept to and the response that has been really having a sense of urgency. The other one I would point out is that we have rightfully so been really upset and angry about the Fast and Furious program because it put guns in the hands of criminals and communities at the hands of the government just to see where they go. Well, I will say again, we don't have any anger, and we're not talking about the fact that every day the DEA and the FBI allow confidential informants to put drugs in urban communities just to see where they go so that they can try to catch a bigger fish, which is the exact philosophy of Fast and Furious, except one uses guns and one uses drugs. And I think that this committee should also ask where those drugs are going. And the fact that really scares me, Mr. Chairman, and I know that members from both sides of the aisle have talked about this, is that the FBI does not keep a track record of the crimes that are committed by their confidential informants and can't tell us how many crimes that people who are cooperating with the government are committing. And that, Mr. Chairman, I think is something that this body, this committee should really look at. And I don't want it to seem like, I don't want the public to have the perception that because that is traditionally an urban problem, that it is not a significant concern of this body. And with that, Mr. Chairman, I will again applaud you on your good work and thank you.
The chair thanks the gentleman. Are there any amendments to H.R. 5046? A reporting quorum being present, the question is on the motion to report the bill H.R. 5046 favorably to the House. Those in favor respond by saying aye. 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 Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. Pursuant to notice, I now call up H.R. 2137 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 2137, to ensure federal law enforcement officers remain able to ensure their own safety and the safety of their families during a covered furlough.
Without objection, the bill is considered as read and open for amendment at any point. I will begin by recognizing myself for an opening statement. Today we consider H.R. 2137, the Federal Law Enforcement Self-Defense and Protection Act of 2015, introduced by Congressman Doug Collins. Federal law enforcement officers face potentially dangerous situations on a daily basis, whether they are on duty or off duty. Accordingly, they are permitted to carry their government-issued firearms on their persons even when they are not on duty. However, during the 2013 government shutdown, at least 3 federal agencies forbade their law enforcement officers from carrying their government-issued firearms or credentials during the furlough. This decision potentially endangered these officers' lives by putting them at an unnecessary risk. Further, it prevented these highly trained officers from being prepared to respond to a critical incident or threat. The Federal Law Enforcement Self-Defense and Protection Act will ensure that officers are able to defend and protect themselves on and off duty by allowing all covered federal law enforcement officers to continue to carry their government-issued firearm during a furlough or government shutdown. As we prepare to honor our nation's law enforcement officers next week during the annual National Police Week, let's ensure that the brave members of the federal law enforcement community have the capability to defend themselves and respond to threatening situations, even in a time of furlough. I want to thank the bill's sponsor, Mr. Collins, for his work on this important issue, and I urge my colleagues to support this bipartisan legislation. It's now my pleasure to recognize the ranking member of the committee, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members, H.R. 2137, the Federal Law Enforcement Self-Defense and Protection Act, would authorize federal law enforcement officers to carry their government-issued firearms during government shutdowns and administrative furloughs that result from lapses in appropriations. I support this common sense bill because it serves a commendable purpose. Essentially, this measure would help ensure that those who protect us are able to continue to do so even during an official furlough. The ability of our federal law enforcement officers to respond to critical incidents should not be impeded, particularly when violent crimes are committed in their presence. H.R. 2137 does not expand federal law enforcement officers' authority to carry firearms. This bill merely authorizes these officers to continue to carry their federally issued firearms as if a furlough had not occurred. This legislation recognizes the very real threat of harm that many of our officers, particularly special agents, face on a regular basis, a threat that does not disappear simply because of a government shutdown. In 2012, for example, more than 1,800 federal law enforcement officers were assaulted, and of those, approximately 200 sustained serious injuries. Even when off-duty, federal law enforcement officers remained the target of assault. Between 2011 to 2014, 27 law enforcement officers were killed while off-duty. Thus, it's vitally important that federal officers be able to protect people in our communities, themselves and their family members, from these threats whenever they occur. Given the fact that H.R. 2137 facilitates this critical goal, I am pleased to support the bill. I urge its very careful examination by everyone on the committee. And, Mr. Chairman, I yield back the balance of my time. Thank you.
Thank you, Mr. Conyers. Without objection, all other members' opening statements will be made a part of the record. Are there any amendments to H.R. 2137? For purposes, the gentleman from Georgia seek recognition.
Mr. Chairman, move strike last word.
Gentleman is recognized for 5 minutes.
Thank you, Mr. Chairman, and I want to thank for holding this markup today on H.R. 2137, the Federal Law Enforcement Self-Defense and Protection Act. And I ask unanimous consent to insert letters of support from the Federal Law Enforcement Association, Officers Association, the Fraternal Order of Police, and the National Association of Police Organizations into the record.
And without objection, they will be made a part of the record.
Thank you, Mr. Chairman. This bill is a targeted solution to a very real problem. Federal law enforcement officers encounter potentially dangerous situations daily, leaving the officers vulnerable to threats. Normally, the federal officers are permitted to carry their firearms 24/7 and 365 days a year. However, during the 2013 government shutdown, at least 3 federal agencies determined that the Anti-Deficiency Act required them to forbid the law enforcement officers from carrying their agency-issued firearms or their personal-owned firearms authorized by the agency. This meant that approximately 1,800 officers were disarmed. This decision put the affected officers at risk, and additionally, policies were inconsistent between agencies. Law enforcement officers are highly trained and know the responsibilities associated with possessing a weapon. It does not make sense to disarm them when they are off duty through no fault of their own. They must be ever vigilant and prepared and ready to respond to a crime or critical incident 24 hours a day, every day. As the kind words of the chairman and also the ranking member pointed out, just in 2012 alone, 1,800 federal law enforcement officers were assaulted with 206 sustaining injury, and then over the past 3 years, 27 law enforcement officers killed in off-duty incidents. We should do everything we can to prevent these tragedies, including ensuring that law enforcement officers have access to the tools they need to protect themselves and the public. H.R. 2137, the Federal Law Enforcement Self-Defense and Protection Act, helps that cause, and I'm glad to see that and know that it's also bipartisan, and I appreciate the work of Congresswoman Gabbard, Congressman Reichert, and also Congressman Pascrell in helping with this bill. You see, it recognizes our law enforcement officers face threats whether they're on duty or off duty and ensures that there is consistent federal policy for the officers. The bill simply states that in an event of a lapse of appropriations or administrative furlough, federal law enforcement officers are authorized to carry firearms on the day the furlough or shutdown begins, and retains the right to carry their government-issued firearm throughout its duration for personal protection or to respond to a critical incident. It does not protect those who are on administrative leave or who have lost the right to carry, nor does it expand firearms carry to authority to law enforcement officers who currently do not possess it. While this is a critical officer safety legislation is narrow in scope, the impact is large. Also, on a personal note, as a son of a Georgia State Trooper who lived in the home of that trooper for over 21 years, I know that my dad, wherever he would go and wherever we would go, was known as a state trooper. It was not unknown. We lived and worked. He lived around the same people that he would stop. He lived around the same people that sometimes would not take too kindly to his being a law enforcement officer. At 6'2", 250 pounds, my dad had some other motivations to be a little intimidating, but the fact that he was able to carry his firearm is an important part of his job. We just need to recognize this, and I think in light of what came up in the 2013 shutdown, this is a common sense piece of legislation that does not expand or carry any other responsibilities. It simply just gives those law enforcement officers the needs, protection that they need to continue to carry their weapons. And with that, Mr. Chairman, I would encourage everyone to support H.R. 2137 and recognize these threats that they face, both on duty and off duty. And with that, I will yield back.
Chair thanks, gentlemen. For purpose, the gentleman from New York seek recognition.
Strike Westward.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I have no objection to this legislation. It's fine as far as it goes. I just want to say that it is inconceivable in a rational government that we will ever have a government shutdown. It's inconceivable that with a reasonable Congress we would ever have a government shutdown. We never talked about such a thing for 200 years of American history. I'd like to say that, but I can't say that because we do not have a reasonable Congress. We had a government shutdown, and it is conceivable that if the majority is, God forbid, reelected, we might have another government shutdown. So being prudent, we have to pass this type of legislation against artificial catastrophes that may be brought upon the people of the United States by the Republican Party. So I support the legislation. I yield back.
Mr. Chairman,
For purposes, the gentleman from Iowa seek recognition.
I move to strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I just was struck by that inconceivable comments of the gentleman from New York, and I would think also that it would be inconceivable that a president of the United States would shut the government down over a $500 million appropriation to Planned Parenthood that would simply prevent Planned Parenthood from using federal dollars to commit abortion. That would be one thing. It's inconceivable, I would think, also that a president of the United States would take an oath to preserve, protect, and defend the Constitution of the United States. Implicit within that, and specifically within the Constitution, he also takes care that the laws be faithfully executed. And yet, when the law requires that those who are encountered, who are in violation and unlawfully present in America, that they shall be placed into removal proceedings, that the president would order the law enforcement officers to defy the very law that they're pledged to uphold. And it would also be inconceivable to think that a president of the United States States could 22 times tell the American people on video that he doesn't have the constitutional authority to grant mass amnesty, and yet we would sit in this committee and listen to testimony from Janet Napolitano, for example, who stressed that prosecutorial discretion was on an individual basis only, and the original document that was the first Morton memo, as I recall, had 7 references to an individual basis only, but it created 4 categories of people, and they granted amnesty according to groups, not individuals, and not on an individual basis only. And as I stood before the United States Supreme Court just a week ago, a week and 2 days ago, it was inconceivable that a case like that would be litigated before the Supreme Court. Now the President argues that he has that authority and went ahead and issued that executive edict, a series of them, known as DACA, DAPA, and the Morton Memos, all of which are unconstitutional, and it was inconceivable to our founding fathers that a president could take an oath to preserve, protect, and defend the Constitution, take care that the laws be faithfully executed, and by his own definitions fail to do so. So I'm glad that we're going to defend this Second Amendment here today, and it is inconceivable to me that a government agency would order their officers when they're off duty to go unarmed instead of having an opportunity to be that very versatile law enforcement force that could be on their off-duty hours effective as well. Thank you, Mr. Chairman. I yield back.
Mr. Chair, thanks, gentlemen. For purposes, gentleman from Idaho seek recognition.
To strike the last word.
Gentleman is recognized for 5 minutes.
Mr. Chairman, I wasn't going to say anything today because these bills, I haven't been working on them, but after the last statement, I just want to remind the members of this committee that the last shutdown, I believe, was the 18th shutdown in the history of this Congress, and 2/3 of those shutdowns happened under the leadership of Tip O'Neill. So for somebody to sit here and lecture the Republicans on shutdowns, maybe they need to go back to learn their own history before they make statements like that.
Chair thanks the gentleman. Are there any amendments to H.R. 2137? Question occurs of a reporting quorum being present. The question is on the motion to report the bill. All right. Given the lack of a reporting quorum, further proceedings on H.R. 2137 will be postponed. Pursuant to notice, I now call up H.R. 5048 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 5048, to require a study by the Comptroller General of the United States on Good Samaritan laws that pertain to treatment of opioid overdoses and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point, and I'll begin by recognizing myself for an opening statement. H.R. 5048, the Good Samaritan Assessment Act of 2016, was introduced by our colleague, Congressman Frank Ginta from New Hampshire. I thank Mr. Ginta, co-chair of the House Bipartisan Task Force to combat the heroin epidemic, for his ongoing efforts on this critical issue. H.R. 5048 directs the Government Accountability Office to study the various Good Samaritan laws in effect in states across the country. Generally speaking, every state has some form of Good Samaritan law which protects from prosecution citizens who render aid in good faith to someone in need of assistance. However, in the context of opioids, Good Samaritan law refers to laws that provide immunity for responding to an opioid overdose by rendering aid or by calling 911. Today, more than half the states and the District of Columbia have enacted some form of Good Samaritan law that provides immunity or limits liability for those who report or treat an opioid overdose. These laws vary widely in application. For example, in my home state of Virginia, the General Assembly passed a Good Samaritan law in 2015. Among other things, that law provides immunity for individuals who contact emergency services to report an overdose. However, Virginia's law is more narrowly tailored than other states' laws. For example, the caller must remain at the scene of the overdose until a law enforcement officer responds. They must cooperate with a criminal investigation reasonably related to the drug or alcohol that resulted in the overdose, and they must identify themselves when law enforcement responds. Given the recent proliferation of these laws at the state level and Congress's desire and duty to address the opioid epidemic, it is fitting that we assess how the various Good Samaritan laws work to protect our citizens and help save lives. H.R. 5048 will direct the GAO to help us get the information we need, and I urge my colleagues to support this legislation. It's now my pleasure to recognize Mr. Conyers for his opening statement.
Thank you, Chairman Goodlatte. Members of the committee, I'm pleased to join the chairman and many of you in supporting H.R. 5048, the Good Samaritan Assessment Act. Like other bills the committee is considering today, this measure provides yet another tool that can be used to combat the raging public health crisis resulting from opioid abuse. The long-term effects of opioid abuse are devastating. They include physical and functional changes to parts of the brain affecting impulse, reward, and motivation. But opioid abuse can have a more immediate and serious consequence, namely an overdose that threatens the life of the victim. In recent years, heroin and prescription opioid drug overdoses have risen sharply. According to the Centers for Disease Control and Prevention, drug overdose death rates more than doubled between 1999 and 2014. In 2014 alone, more than 47,000 people died from drug overdoses, the highest of any previous year. Yet many of these drug overdose deaths could have been prevented through the administration of opioid reversal drugs such as naloxone. The package of legislation we're passing today will facilitate the provision of medication-assisted treatment, including helping first responders obtain and administer drugs that revive overdose victims. But to be effective in saving lives, these drugs must often be administered on an emergency basis. Family, friends, and other users and first responders are frequently in the best position to administer a reversal drug. But witnesses to an overdose often hesitate or fail to call 911 for fear that they might be prosecuted, held responsible for their involvement, or held liable if something goes wrong. To alleviate such concerns and help ensure that overdose victims receive timely medical treatment, the Office of National Drug Control Policy has been working with states and municipalities to enact Good Samaritan laws to protect first responders, caregivers, and others who call for emergency assistance in overdose cases or administer opioid reversal drugs or devices against civil or criminal liability. And so today, 35 states and the District of Columbia have some form of a Good Samaritan or a 9/11 drug immunity law. The protections vary from state to state. This bill, H.R. 5048, calls for the Government Accountability Office to conduct a study and report to the appropriate committees of Congress on the Office of National Drug Control Policy's work in expanding Good Samaritan protections. Specifically, the study would analyze any law that exempts from criminal and civil liability individuals who administer opioid reversal drugs or devices or who contact emergency service providers in response to overdose incidents. By encouraging expansion and greater uniformity of Good Samaritan protection for those who seek or administer potentially life-saving opioid overdose reversal treatment, this bill will contribute to the comprehensive effort needed to combat the growing scourge of opioid abuse. And so accordingly, I urge all of my colleagues to support its passage. I thank you and yield back.
Thank you, Mr. Conyers. Without objection, all other members' opening statements will be made part of the record. Are there any amendments to H.R. 5048? Given the lack of a reporting quorum, further proceedings on H.R. 5048 will be postponed. Pursuant to notice, I now call up H.R. 3394 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 3394 to amend the Terrorism Risk Insurance Act of 2002 to allow for the use of certain assets of foreign prisoners and entities to satisfy certain judgments against terrorist parties and for other purposes.
Without objection, the bill will be considered as read and open for amendment at any point, and the manager's amendment in the nature of a substitute, which the members have before them, will be considered as read, considered as the original text for purposes of amendment, and open for amendment at any point. I'll begin by recognizing myself for an opening statement. I would like to begin by thanking Representative Posey and Judiciary Committee members Dave Trott, Ted Deutsch, Hank Johnson, and Randy Forbes for introducing this bipartisan legislation. The Captive Act makes two small but important changes to Section 201 of the Terrorism Risk Insurance Act to make it easier for U.S. victims of terrorism to recover court-awarded damages from the perpetrators of terrorism. Under current federal law, victims of terrorism may satisfy a court-awarded judgment that they have against a terrorist party out of any assets of that terrorist party that the federal government has frozen pursuant to the Trading with the Enemy Act or the International Emergency Economic Powers Act. The Captive Act amends this provision to provide that assets frozen by the federal government pursuant to the Foreign Narcotics Kingpin Designation Act are also available to satisfy judgments against terrorist parties. This is an important change in the law in cases involving narco-terrorists like the FARC that may be cross-designated as both terrorists and drug kingpins. In cases involving narco-terrorists, the group may be designated as a terrorist organization, but its assets may be frozen under the Kingpin Act, thus preventing terrorism victims from satisfying their judgments against those assets. This is more than a hypothetical problem. Several weeks ago, I met with some of the victims and family members of the victims of a 2003 FARC terrorist attack. On February 13, 2003, Keith Stansel, Mark Gonsalves, Thomas Howes, and Thomas Janis were flying over Colombia while performing counter-narcotics reconnaissance for the Department of Defense. Members of FARC shot their plane down, and after the plane crash-landed, FARC captured the group. FARC immediately executed Thomas Janis, a Vietnam veteran, Bronze Star recipient, and former member of Delta Force. They took the other survivors hostage, holding them in captivity for over 5 years, during which time they were tortured, starved, and suffered through repeated mock executions. After they were rescued and returned to the United States, the survivors and Janis' family successfully brought a suit against the FARC under the Anti-Terrorism Act. However, because blocked Kingpin Act assets are not covered under Section 201 of the Terrorism Risk Insurance Act, this group of victims has found it nearly impossible to satisfy their judgment. It makes little sense for the law to reach terrorist organizations like the FARC, but then prevent the victims from executing on FARC assets merely because the executive branch blocked these terrorist assets under the Kingpin Act. The Captive Act fixes this problem. In addition, to make Section 201 consistent with the civil liability provision in the Anti-Terrorism Act and the state-sponsored terrorism exception to the Foreign Sovereign Immunities Act, the Captive Act defines the term person as limited to U.S. nationals, members of the armed forces, and U.S. government employees and contractors. This change will prevent foreign nationals, who Congress has specifically excluded from the ATA, and state-sponsored terrorism Foreign Sovereign Immunities Act cases from depleting the limited pool of blocked assets available to U.S. terrorism victims. I urge my colleagues to support this bipartisan legislation to provide victims of narco-terrorism some measure of financial justice against the terrorist groups that have caused them severe harm. It is now my pleasure to recognize the ranking member of the committee, the gentleman from Michigan, Mr. Conyers, for his opening statement.
Thank you. Chairman Gillett and members of the committee, the measure before us, H.R. 3394, the clarifying amendment to provide Terrorism Victims with Equity Act, or briefly called the Captive Act, would amend the Terrorism Risk Insurance Act to allow terrorism victims to satisfy court judgments from the assets of certain terrorist parties, including the assets of any agency or instrumentality of a particular terrorist party blocked or seized by the United States government pursuant to the Foreign Narcotics Kingpin Designation Act. Now, currently, the Terrorism Risk Insurance Act allows terrorism victims to attach only those assets frozen or seized pursuant to the Trading with the Enemy Act or the International Emergency Economic Powers Act. I support this bill as amended by the substitute amendment with the following factors in mind. To begin with, H.R. 3394 will enhance the ability of narco-terrorism victims to satisfy court judgments obtained against terrorist perpetrators. This legislation stems from the tragic events surrounding the fates of 4 American military contractors who were on a drug surveillance mission in Colombia in 2003. After their plane crashed, they were captured by members of the Fuerzas Armadas Revolucionarias de Colombia, or FARC, a guerrilla group designed as a foreign terrorist organization and as a narcotics trafficker under the Kingpin Act by the United States. One of the Americans was executed, as has been indicated, at the crash site, and the other 3 were held hostage and tortured for more than 5 years until their rescue by the Colombian Armed Forces. The survivors, as well as the relatives of the deceased American contractor, filed suit against the FARC in federal court and won a judgment for damages in excess of $300 million. In seeking to enforce their judgment against a blocked bank account affiliated with a FARC commander, however, the plaintiffs could not reach this asset because it had been blocked pursuant to the Kingpin Act and therefore was not a blocked asset under the Terrorism Risk Insurance Act. H.R. 3394 will ensure that these and other victims of terrorist acts committed by the FARC and similar entities will be able to reach its assets and those of its agents and instrumentalities and to make their victims whole, or as whole as possible. In addition, I appreciate that the majority of this committee has accepted the important feedback from the Department of Justice. As amended by the substitute amendment, H.R. 3394 reflects the Department's input by removing a problematic provision and clarifying others. Most importantly, it strikes Section 2 of the bill as introduced. That section would have allowed blocked assets of a terrorist party to still be subject to execution or attachment to satisfy a civil judgment against it, even if the terrorist party ceased to be a terrorist party after the judgment was entered. This provision is unnecessary, as a plaintiff could simply subject to execution or attachment the assets of a former terrorist party under normal civil enforcement procedures because such party's assets would no longer be blocked. Moreover, this language could have negatively impacted the foreign relations of the United States with, for example, new regimes in Libya and Iraq. The substitute amendment also clarifies that the amendments made by the bill apply only to judgments to which the Terrorism Risk Insurance Act applies, rather than to all judgments, as the original language implied. These changes greatly improve upon the bill as introduced. Finally, while I support this legislation, I must note that the committee has held no hearing on it. As we know, regular order allows our members to consider whether there is a problem that requires a legislative response, and to hear from a variety of viewpoints as to what that response should be. While on its face, H.R. 3394 appears not to be problematic, a hearing would have allowed us to identify any potential unintended consequences. For instance, the Treasury Department expressed some concern at a hearing before the Financial Service Committee 2 years ago that this proposal could reduce the department's ability to obtain the cooperation of narcotics traffickers or to influence their behavior for the better. Nevertheless, the Treasury Department has not formally opposed H.R. 3394, and the bill's equities thus far appear to favor supporting this bill as amended, and so do I. Mr. Chairman, I thank you and yield back the balance of my time.
Thank you, Mr. Conyers. Without objection, all other members' opening statements will be made a part of the record. For what purpose does the gentleman from Michigan seek recognition?
Move to strike the last word.
Gentleman is recognized for 5 minutes.
Mr. Chairman and Ranking Member Conyers, thank you for marking up this important legislation that I'm proud to co-sponsor. This bill will correct an omission in current law that prevents American victims of terrorism from recovering assets held by terrorist organizations linked to narco-terrorism. This simple correction to the law is long overdue. As has been mentioned, in 2003, a plane carrying contractors hired by the U.S. government to find and eradicate cocoa fields in Colombia was fired upon by the Revolutionary Armed Forces of America, FARC, and had to make an emergency crash landing in a mountainside. The plane was quickly surrounded by members of FARC. Tom Janis, a retired Delta Force pilot, was marched away from the plane and executed. Also on the plane were 3 Americans, Keith Stanzel, Tom Howes, and Mark Gonzalez. They were not injured in the crash, but they were taken hostage by FARC and marched into the jungles of Colombia, where they were held captive, starved, and horrifically tortured for 5.5 years. After their capture, the 3 Americans' exact location was lost by U.S. intelligence until July 2, 2008, when they were finally rescued in a daring mission by the Colombian Army called operation called JOC. Each has been awarded the Defense of Freedom Medal. FARC is a Colombian narco-terrorist group and the world's largest supplier of cocaine. In 2010, these victims obtained a judgment under the Anti-Terrorism Act for damages against FARC and are now pursuing collection efforts to satisfy the judgment. Any potential collection will come from primarily blocked assets of agencies and instrumentalities of FARC. There is a large pool of drug profits blocked under the Kingpin Act, but these assets are not currently subject to attachment by victims of terrorism, absent an amendment clarifying TRIA. As a result, more than 6 years later, after the judgment has been entered, the victims have not been compensated and there is no justice. They deserve closure from this horrible period in their lives. As the chairman noted, this bill provides for a simple clarification to Section 201 of the Terrorism Risk Insurance Act of 2002 to allow American victims of terrorism to collect blocked assets derived from drug proceeds. I urge my colleagues to support this important legislation and move it to the House floor quickly. Thank you, and I yield back.
Chair, thanks, gentlemen. For what purpose does the gentleman from Florida seek recognition? Does not seek recognition. Are there any amendments to H.R. 3394? Given the lack of a reporting quorum, further proceedings on H.R. 3394 will be postponed. We're working on it. Pursuant to notice, I now call up H.R. 5052 for purposes of markup and move that the committee report the bill favorably to the House. The clerk will report the bill.
H.R. 5052, to direct the Attorney General and the Secretary of Health and Human Services to evaluate the effectiveness of grant programs that provide grants for the primary purpose of providing assistance in addressing problems pertaining to opioid use and for other purposes.
Without objection, the bill is considered as read and open for amendment at any point, and I'll begin by recognizing myself for an opening statement. H.R. 5052 is a bill that will require an evaluation of the Comprehensive Opioid Abuse Reduction Grant Program authorized by H.R. 5046 and a number of complementary bills authorizing grants to address opioid abuse that have been marked up by the House Energy and Commerce Committee. This is a bipartisan bill sponsored by Majority Leader Kevin McCarthy and Minority Whip Steny Hoyer. The Opioid Program Evaluation Act, or OPEN Act, requires the Attorney General and Secretary of Health and Human Services to enter into an arrangement with the National Academy of Sciences to identify outcomes that are to be achieved by the activities funded by Congress to address opioid abuse, develop the metrics by which each program's performance will be evaluated, complete an interim evaluation assessing the nature and extent of opioid abuse and illegal opioid distribution in the United States, and carry out an evaluation of the effectiveness of the programs. Additionally, to increase transparency and facilitate the evaluation of the performance of the programs, the bill requires grantees to collect and annually report data on the activities conducted pursuant to these programs. Evaluations such as these can be Congress' best measure of how well a federal program or agency is operating. At its conclusion, we hope to learn, for example, whether a substantial number of criminal justice agency personnel have received training on substance abuse disorders and co-occurring mental illness and adapted their procedures accordingly. We also hope to learn the extent to which offenders offered a treatment alternative to incarceration have benefited from a response that integrates substance abuse services into the traditional criminal justice system. I welcome the important contribution this bill makes to the House Judiciary Committee's oversight efforts. The timely availability of data mandated by this legislation will be a key factor in the ability to assess program performance. I agree with the bill's sponsors that Congress must demand greater achievement and increased transparency and accountability with respect to our federal grant programs. I urge my colleagues to support H.R. 5052. It's now my pleasure to recognize the ranking member, Mr. Conyers, for his opening statement.
Thank you, Chairman Goodlatte. Members of the committee, I'm pleased to support H.R. 5052. Also, the brief name is the OPEN Act. This common sense measure will provide a meaningful way to evaluate the effectiveness of various efforts being undertaken to combat opioid abuse epidemic that is currently afflicting millions of Americans. H.R. 5052 is yet another in a series of bills that our committee, along with other committees in the House, are considering to help stop the spread of this devastating epidemic. For example, the Comprehensive Opioid Abuse Reduction Act, which we just considered, will provide a critical funding assistance to states so that they can create and implement a wide variety of strategies, including alternatives to incarceration designed to reduce opioid abuse. This new grant program established by that legislation has tremendous promise, in my judgment, as it will enable criminal justice agencies to focus on what they believe will be most effective based on their specific needs. Jurisdictions, for instance, may choose to implement the law enforcement assisted diversion approach established with success in Seattle and which is beginning to be used in other cities. And that bill would also assist with the provision of medication-assisted treatment and help first responders prevent deaths by allowing them to obtain and administer drugs that revive overdose victims. Strategies like these are worthy of our support, and while we're confident in their usefulness, I also support tracking the success of the grants. The Open Act will aid us in assessing the effectiveness of these grants based on metrics developed by the Justice Department to evaluate the outcomes achieved by program grantees. These results, in turn, will be studied and reported on by the National Academy of Sciences. The approaches to dealing with opioid abuse should be based on evidence of their effectiveness and ability to save lives. And accordingly, I urge my colleagues to support H.R. 5052 because it will enable us to evaluate the success of their implementation. I thank the chairman and yield back the balance of my time.
Chair thanks, gentlemen. Without objection, all other members' opening statements will be made a part of the record. Are there amendments to H.R. 5052? For purposes, the gentleman from Texas seek recognition.
Strike the last word.
Gentleman's recognized for 5 minutes.
Thank you, Mr. Chairman. I considered raising a point of order against this bill, not because I'm opposed to it, because it was just filed yesterday, and our committee rules require 48 hours notice of a bill unless it's an emergency. I can't imagine a study being an emergency. However, in the meantime, I did have the opportunity to read the bill, even though it just came out, and I can't see any reason anybody would be opposed to it. It's a good government bill, making sure the money we spend of the taxpayers is well spent, and we know the results of what's happening. But I am concerned that we do not set a precedent. It's necessary that we have access as members of Congress to these bills with sufficient time for us to read and understand them and contact the experts that we represent. On this bill, had it actually had anything of that I thought would be possibly controversial, I would have liked to have talked to my law enforcement, medical, and recovery communities in the district I represent. So I just wanted to express my concern at the very short time frame some of these bills. The second bill we did today, I think it barely met the 3-day rule. So with that, I'll yield back the remainder of my time.
Would the gentleman yield?
The gentleman yields.
First, I want to thank the gentleman for not raising a point of order. I want to thank the gentleman for raising the issue, however, because I think all of us should be concerned about due deliberation of legislation coming before this committee. A couple of things that I am aware of. One, the bill was posted in a timely fashion. The problem arose when some changes were made to the bill, and those changes were posted less than 48 hours. However, the committee rules provide that upon concurrence of the chairman and the ranking member, that can take place in less than the 48-hour.
Well, reclaiming a second of my time, the exception is it says in an emergency does not reasonably allow for notice as a requirement. Again, I can't see an emergency arising with a study bill. But again, I don't want to belabor the point.
Well, I think again the desire of I think most members of the committee to move this package of bills to the floor in a timely fashion necessitated some expedited consideration, which the ranking member very graciously agreed with us should take place. But the gentleman's concern is well taken, and this is not our preferred method of notifying members of changes to legislation that come before the committee. And so I thank the gentleman for bringing it to everyone's attention, and also thank him for not raising a point of order. Are there any amendments to H.R. 5052? The reporting quorum being present, the question is on the motion to report the bill H.R. 5052 favorably to the House. All those in favor respond by saying aye. Aye. Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. We'll now return to H.R. 2137. A reporting quorum being present, the question is on the motion to report the bill H.R. 2137 favorably to the House. Those in favor will respond by saying aye.
Aye.
Those opposed, no. The ayes have it, and the bill is ordered reported favorably. Members will have 2 days to submit views. We'll now return to H.R. 5048. A reporting quorum being present, the question is on the motion to report the bill H.R. 5048 favorably to the House. Those in favor respond by saying aye.
Aye.
Those opposed, no. The ayes have it. The bill is ordered reported favorably. Members will have 2 days to submit views. We'll now return to H.R. 3394. A reporting quorum being present, the question is on the motion to report the bill H.R. 3394 favorably to the House as amended. Those in favor will respond by saying aye.
Aye.
Those opposed, no. The ayes have it. The bill as amended is ordered reported favorably. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. This concludes our business for today. Thanks to all of our members for attending, and this markup is adjourned.
Thank you.